Committee will come to order, and our first item of business is request for bill introductions. So do we have any? Yes, Senator Pittman.
Thank you, Madam Chair.
Please introduce yourself and welcome to committee.
Absolutely. My name is Senator Jeff Pittman, representing Leavenworth, Lansing, and Bay City and Western Wyandotte, and I am here to introduce 24 RS 2941. It's a bill dealing with cameras inside of correctional facilities and increasing the penalty when they get covered up during a riot. And this is on behalf of my county attorney, Todd Thompson.
Thank you. The bill will be introduced.
Thank you, ma'am.
Thank you. Do we have other requests for bill introductions? Yes, please introduce yourself and welcome to committee. Can we make sure your microphone is on, and please reintroduce yourself? Thank you.
Yes, sorry. Madam Chair, my name is Bob Stewart. I'm the Executive Officer for the Kansas Bureau of Investigation. I'm here to introduce 24 RS 2553, and that concerning criminal history and record checks relating to the Kansas Bureau of Investigation.
Thank you. The bill will be introduced. Sure, come on up. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Ed Klump. I'm representing the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. I have a bill request on behalf of those three associations. It is 24 RS 2967. It deals with notice to appears and complaints for non-person misdemeanors.
Thank you. The bill will be introduced.
Thank you.
Thank you. Committee, do we have other requests for bill introductions? Yes, Senator Wilborn.
Thank you, Madam Chair. I would like to introduce RS 2979, 24 RS 2979, an act regarding driving privileges.
Thank you. The bill will be introduced. I do have a bill to introduce. It is 24 RS 2684, and it concerns health and healthcare relating to emergency care liability for rendering aid in the form of CPR or using an AED device if you hold a valid certificate to do so, to protect you from liability. So do we have any other requests for bill introductions? Last call, folks. Not seeing any then. Thank you, everyone, for your attention. And we will now be opening the hearing on Senate Bill 379. Senate Bill 379 provides a longer time for notice to creditors by publication when a petition for administration or probate of a will is filed. And we will have a bill brief from our reviser, Jenna Moyer.
Good morning, committee. Thank you, Madam Chair. Jenna Moyer, Revisor's Office, filling in for Jason today, who couldn't be here. This is Senate Bill 379, and as the chair said, it provides a longer term of notice for creditors for publication when a petition for administration of a probate or will is filed, and it changes the process for transferring that personal property in those small estates and modifies some time requirements for public notice by publication related to public auction sales in the Kansas Probate Code. Section 1 amends KSA 59709, and that is the probate statute that currently requires every petitioner, if you're filing a will or if you're filing a petition for the administration or probate of a will, you're currently required to give notice of that filing within 10 days to those creditors, and this bill would require notice within 30 days after that filing, and all other requirements in that section remain the same. Section 2 amends KSA 1507B, and that's the probate code statute that provides the process for transferring personal property by affidavit in small estates. In current law, if the total assets of the estate of the decedent subject to probate do not exceed $75,000 in value, any personal property transferable to that decedent's estate would have to be transferred to a person claiming to be a successor of the decedent, or in a manner as directed by the successor upon such successor furnishing an affidavit showing they are entitled to this transfer. And you'll notice that first change or that change of successor is on page 2, line 1, and it would also define successor as a person in subsection C entitled to the property by will or intestate succession or nominated as a personal representative under the decedent's will. Section 3 amends KSA 592243, and that's the probate code statute that governs the sale of personal property at a public auction. Under current law, the personal representative in all sales at public auction is required to give a notice that contains a description of the property to be sold, stating the time, terms, place of sale, and it has to be by publication once, not less than 10 days before the date of sale in a newspaper authorized to publish legal notices in that county. The bill would add a provision requiring that if the sale is being held as an auction and that sale takes place over multiple days, then that notice would be required to be published not less than 10 days before the first day that the auction is open for bidding. And Section 4 amends KSA 592308 similarly to Section 3. And current law provides that the date for sale at a public auction shall be not earlier than 10 days and not later than 30 days after the date of the last publication of notice. The bill would add a provision requiring that if the sale is being held as an auction that takes place over more than one day, that first day that the auction is open for bidding shall not be earlier than 10 days and not later than 30 days after the date of the last publication notice. The bill would take effect after publication of the statute book, which is July 1st. I'll be happy to answer some questions.
Well, it's a pretty short bill, right? It's a front and a back, but it's got a lot of content in it. So thank you for covering that very thoroughly for us. It's 4 sections, and again, pretty short, but pretty impactful to the practice of law in that area. Committee, any questions for the reviser? I'm not seeing any. And before we proceed, however, I wanted to take just a moment. I see that we have, it appears to be a number of students in the committee meeting room today. If you have a spokesperson who might want to come up and introduce your group, and we can say hello and give a quick welcome. Go ahead, please introduce yourself.
Hi, I'm Spencer Timcar. We are from Bishop Seabury Academy in Lawrence, and we're going around and checking out different meetings today. And yeah, so.
Okay, well, great. Well, welcome to a committee, everyone. Thanks for coming to the Capitol today. Okay, then we will ask for our first proponent in-person conferee, Kent Meyerhoff with the Kansas Judicial Council. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, committee. As you heard, my name is Kent Meyerhoff. I'm an attorney with the Fleece and Gooing firm down in Wichita, also a member of the Probate Law Advisory Committee for the Kansas Judicial Council. And it's in that capacity that I'm here before you today as a proponent of Senate Bill 379. As you heard from the explanation and summary, this bill is short but impactful. It does make changes to 4 statutes, all in the probate code of the Kansas statutes, which is Chapter 59. Probate is, of course, a procedure that occurs after someone passes away to help pass property on and administer the estate. One of the changes I'll refer to as a cleanup change, and I'll explain what I mean about that here in a moment. And the other 3 are really clarification changes. And again, I'll explain what I mean about that in a moment. With the chair's permission, even though we've got section 1, 2, 3, and 4, I'd like to talk about section 1, 3, and 4, which are the notice provisions. And then we'll circle back to section 2, which is small estate affidavit, if that's okay.
Sure, go ahead.
Okay, great. Section 1 would amend KSA 59-709. That requires when there is a petition filed for probate of a will or for administration of an intestate estate, meaning there wasn't a will, at the time the petition is filed, there's a requirement that the petitioner publish a notice in the newspaper. We refer to it as a notice to creditors. It's a notice that says if you think that decedent owed you money, you have 4 months from that first publication date to file a claim with the court if you wish to be paid. Right now, the statute requires that that notice be published within 10 days after the petition is filed. And the main reason for the change to this statute this year, this is the one I referred to as cleanup. Last year, there was a change made to 592209, which is a provision of the probate court code that requires notice sometimes to be published of the hearing that will occur on the petition. And the change that was made last year to 592209 was to change the time frame from 10 days after the date the petition was filed to 30 days. These notices often are published in the same publication notice for efficiency and for costs. That way there's only one publication instead of two. And so it makes sense for both of these to have the same deadline. The reason for the change last year and the change this year as well from 10 to 30 has to do with the fact that there are fewer and fewer newspapers in the state to choose from. For example, I grew up in a farm in Washington County, up in north central part of the state. When I was growing up, we had at least 4 weekly newspapers. I was trying to think this morning, I know at least 4. Now, to my knowledge, we have 1. So there's 1 choice instead of 4 for that publication. And this is not an example for the Washington County News, which is still the existing publication up there. But this is actually a newspaper down in the Wichita area. The deadlines for this particular publication publishes either on Tuesday or Wednesday. I can't remember for sure. But if you want something published in that Tuesday or Wednesday weekly version, you have to have your material to them by noon on the Friday before. And so if I file a petition Friday afternoon, I'm not going to get that information to the newspaper until Friday afternoon, which means I missed their noon deadline, which means it won't be published until a week from that following Tuesday or Wednesday, which is beyond the 10 days. And so a practitioner brought this to our attention, the Probate Law Advisory Committee last year about that issue, and sometimes that can cause problems. And so that's why 2209 was changed. And frankly, this one I think was just overlooked since they are kind of in tandem, and that's why it makes sense, in our opinion, to change this one also from 10 days to 30 days, just so they match. Sections 3 and 4. Section 3 and 4 do much the same thing. Section 3 would amend KSA 592243. Section 4 of the bill would amend 592308. 2243, which is Section 3, deals with auctions of personal property. Section 4, which is 2308, deals with auctions of real property. And this is one that I put in the clarification category. Right now, as the law is set forth, if there's going to be an auction, the sale, the notice for public personal property needs to be not less than 10 days before the date of the sale in some newspaper. As you probably know, it's fairly common these days to have auctions that occur over multiple days, sometimes multiple weeks. Many of those are online auctions. In fact, a lot of real estate is sold that way. It's not an auction on a one day where you show up and have the auction, but it's listed and available, and you can place bids for several days or, again, sometimes multiple weeks online. There was a question raised, what does it mean, the date of sale? Does that mean the first day the auction is open, so when the sale opens? Or at an auction, the sale technically does not occur until the gavel falls and no further bids are taken. So there was a question, what does that 10 days apply to? If we've got an auction that's occurring over a 2-week time period, does that notice have to be published 10 days before the commencement of the auction, or 10 days before it ends, which is when arguably the sale takes place? So what this would do in both of those statutes, again, one for personal, one for real property, it clarifies, it says the sale, if it's being held as an auction that takes place over more than 1 day, the notice shall be published not less than 10 days before the first day that the auction is open for bidding. And for real estate, we've got a window. It's not earlier than 10 days and not later than 30 days. But again, the addition that we're proposing be added makes clear that the term sale means when the bidding is commenced, so the first day of the sale. That way there's not a question, because I've heard it argued both ways, that, well, sale doesn't occur until the auction is concluded. So we thought it best, before it becomes an issue, to clarify that in both of these statutes. And then moving back to section 2 of the bill, this is again for clarification, in my opinion. This would amend 59-1507B, which we refer to as the small estate affidavit. What the small estate affidavit is it applies to property that would otherwise be subject to probate. So that means property that, I'll use myself as an example, if I died and I owned property in my name alone, there was not a co-owner as a joint tenant with survivorship rights, and I did not name a beneficiary either as a beneficiary or a pay on death or transfer on death, it was solely in my name. Under Kansas law, that says my estate should have to go through probate and get a court order transferring that property to either my beneficiaries under the will, or if I was intestate, to my heirs at law. The small estate affidavit procedure, which has been in the Kansas statute for years, it allows in certain cases when there is a relatively small amount in the probate estate for there to be a procedure by affidavit that allows the person who otherwise would be entitled to those assets, if there were a probate proceeding, to present an affidavit to the holder of the property and allow that holder to turn over the property based on that affidavit. It's commonly used. The two most common things, in my experience anyway, I think the rest of the committee, would be bank accounts or sometimes automobiles. Bank accounts, for example, you might have had a bank account that's got $5,000 in it, and everything else in the estate has been transferred in one way or another. Either they did their planning with a revocable trust and transferred their assets to the trust, or they had beneficiary designations or co-owners on everything else, but you had a $5,000 bank account that got missed. This affidavit allows that property, that bank account, to be claimed by those entitled to it without having to have the cost and expense of opening up a probate with the filing fees and the publication fees we just talked about, eating up a chunk of that bank account. Another one is automobiles. People often forget about their automobiles entitling. If they do a revocable trust for their planning, they often forget that they either need to transfer that vehicle to the trust or put a transfer on death that transfers it to the trust or to a beneficiary. And so that's another category that often is in that. There's one item, and as long as it's below currently $75,000 in value, it can be, the affidavit procedure can be used. And what this does, the reason I'm saying the proposed changes clarify things, the statute currently provides is that the property could be transferred to the successor or successors of the decedent. And there's been some question out in practice. Say you've got, let's use an intestate example. So they didn't have a will, and there are 3 heirs. Do all 3 have to sign the small estate affidavit and be present and present it? Or could one sign it on behalf of the 3, asking or instructing the bank, in my example, to distribute that account in 3 shares? It seemed to be the consensus of our committee that most people in practice have believed one person could sign that on behalf of the 3, asking the bank to distribute to the 3 heirs. The other question that came up is, many people these days, at least down in the Wichita area and even in rural areas of the state, use revocable trusts for their planning. And in connection with a revocable trust, you often have a will that we refer to as a pour-over will. And the sole function of that pour-over will is to add or pour whatever wasn't already in the trust at the time of death into the trust. So the idea being the trustee has control over everything that the trust says to be submitted. A question came up whether, when you've got a pour-over will situation and you've got a trust, the language of the statute as written says it's got to be transferred to a successor. And question was, well, a personal representative under a will, they're not the ultimate recipient of the property, but they are the person who is going to take control of that to make sure it's distributed to the intended beneficiaries or successors under the terms of the trust. And so part of the clarification is to make clear that one person can sign the affidavit attesting to the person or the company they're presenting it to that I'm under oath saying, this is accurate facts, and I'm going to make sure that this gets to the people that it's intended to go to, and also makes clear that a personal representative under a will could function in that role. That's where the definition comes in. The definition of successor is a new addition, section C, which is on line 3 of page 2, where it says successor means a person entitled to the property by will or intestate succession, or, and this is where the further clarification is, or nominated as a personal representative under a decedent's will, to make clear that a executor under a pour over will can submit that small estate affidavit, take that cash or vehicle, add it to the trust by that, and then distribute per the terms of the trust. And I'd be happy to take any questions on any of those sections.
Thank you, Mr. Meyerhoff. Appreciate that. Committee questions? Yes, Senator Stephan.
Thank you. On section 2, can you explain to me the affidavit procedure and who the decision makers are in that process?
Sure. The affidavit, I'm going to use a bank account as the example. So let's say there's a bank account with my $5,000 that I referenced before. The person presenting that affidavit, that's the person putting things in play, if you will, that is typically going to be one of two people. It may be, if there's an intestate situation where there's not a will, it's probably going to be the heirs entitled to that bank account. So $5,000, I'm going to make it 5 heirs for easy math. That affidavit would be presented to the bank at which the account is held. And that affidavit is telling the bank that I am the successor entitled to receive this bank account. And the modifications say that the successor, being the person presenting the affidavit, can either ask the bank to deliver it to the successor with the promise that that successor will distribute it to the other 4 people, or maybe 5 if it's an executor under a will, or can request that the bank make distribution directly to the 5 intended beneficiaries. So it's the affiant, the person presenting the affidavit, and whoever is holding or in possession of that property. If it's a bank account or if it's an automobile, it depends on who's in possession of that property. With the automobile, you'd be going to the Department of Motor Vehicles, or as we call it in Sedgwick County, the tag office. You take that affidavit with the title and present it at that point. You're welcome.
Thank you. Committee, any other questions? Not seeing any. Thank you very much for your thorough presentation about the bill and the changes that it would make should it become enacted into law. And thank you very much for appearing in committee today. Appreciate it.
You're welcome. Thank you.
Thank you. Are there any other proponents of the bill in the committee meeting room or on WebEx? Not seeing any. Do we have any neutral conferees in the committee meeting room or on WebEx? Do we have any opponents of the bill in the committee meeting room or on WebEx? Not seeing any. Then we will close the hearing on Senate Bill 379. We are going to open the hearing on Senate Bill 412, modifying criminal sentencing rules. And with that, then we will have the bill brief from the reviser. Thank you, Ms. Moyer.
Thank you, Madam Chair. Jenna Moyer again, Reviser Statutes Office. Senate Bill 412 modifies criminal sentencing rules that are applicable in multiple conviction cases where consecutive sentences may be imposed by the sentencing judge and the sentence for the primary crime is a non-prison sentence. This bill amends KSA 216819, and that's the criminal code statute that governs sentencing in multiple conviction cases. The changes on page 1 are all cleanup. The current law in subsection B provides that in cases where consecutive sentences may be imposed by the sentencing judge, several rules apply. Subsection B8 provides that if the sentence for the primary crime is a non-prison sentence, a non-prison term will be imposed for each crime of conviction. But the non-prison terms shall not be aggregated or served consecutively, even though the underlying prison sentences have been ordered to be served consecutively. The bill removes the words aggregated or and adds 2 additional provisions. The supervision term would be based on the longest supervision term imposed for any of the crimes and the supervision durations set forth in KSA 216608C1, C2, C3, and C4 shall not apply. And two, such an increase shall not be considered a departure and not be subject to appeal. And the bill would take effect from and after publication of the statute book, which is July 1st.
Thank you. Committee questions? Not seeing any. Thank you. We will then invite proponent in-person conferee Melissa Schoen with the Kansas County District Attorneys. Please introduce yourself and welcome to committee.
Thank you. Madam Chair, thank you. My name is Melissa Schoen. I am the Norton and Phillips County Attorney from out in western Kansas. Here today representing Kansas County District and Attorneys Association, asking for your support of Senate Bill 412. This is a small fix for a big issue. Became apparent to myself last year when I had an appeal. It is actually a fix from State v. Baker, which is a 2017 Court of Appeals opinion, and did not come into play in my world until 2023 on an appeal. It's common in plea negotiations to work out a plea negotiations is working out a deal. And it's very common in my world to say, okay, how about 36 months DOC or 36 months probation with a longer underlying sentence, giving an individual the chance at probation. To get that large amount, you have to stack or run underlying sentences consecutively. Very common, those underlying sentences, as stated in my written testimony, have different probation lengths. And those probation lengths are set out within our Kansas sentencing guidelines. To follow the statute, well, we haven't been following the statute for years. We've not interpreted the statute the way our Court of Appeals did. We used to think, or probation term was the full length of the longest sentence. Court of Appeals said no, those individual probation terms expire. So in my case, I had a woman and she was convicted of 3 crimes. One was a level 7, so she had 24 months of probation. One was a level 8, and she had 18 months of probation on that sentence. And the third was a level 9 and carried a length of 12 months probation. Per plea negotiations, we ran those 3 counts consecutively with an underlying sentence of 36 months. 22 months into her probation period. So she's almost done. She commits new crimes. So I file a motion to revoke her probation. The court revoked her probation and sent her to the Department of Corrections for her underlying sentence of 36 months. She appealed her sentence, and the Court of Appeals interpreted or reapplied State v. Baker from 2017 and said that because those 2, the level 8 and the level 9, carried shorter months of probation, and I filed at 22 months, that the 12 months of probation had expired and the 18 months had expired, and she could only be sentenced to the Department of Corrections for the amount of time that was left on the 24-month sentence. She committed a serious crime. She was given a chance at probation. The sentence imposed was, if you mess up, we want you to be held accountable. Our Court of Appeals said those 2 underlying sentences expire, and she could only go to the Department of Corrections for 18 months. By fixing and adding the language or taking out the aggregated language and stating that the supervision term will be based on the longest supervision term, everything runs the same. All of your underlying sentences remain in play, and we're not trying to figure out what's expired, what's still in play, where are we at? If you don't have this fix or we do not get this fix, it's up to then myself as a prosecutor to always make sure and ask that my judge use magic language, as we call it, to extend those underlying probation terms, make sure everything runs the same. And then I've got to make sure my judge knows why I'm asking for this and that everybody understands what's going on. And it's something I always have to remember to do then, to have everything be in play if there is a probation revocation. There's also some issues. Our current case management system that our probation officers use does not track individual probation lengths in a multi-count conviction. Their program just says this defendant is on probation for 18 months. It doesn't let them know there is a shorter underlying probation period on another count that, following State v. Baker, expires. We do not have a way, a mechanism to come in and extend that 12 months of probation if we're 16 months into probation and they don't have all their fines and fees paid. They're still subject to probation because they had another count that had 24 months. But we don't have a way to extend that 18 months to keep everything going at the same time. That is why we need this fix in Senate Bill 412. Without this fix, we're looking at opening the door, or the door is there, but more work for our Court of Appeals, more people asking that their sentences be appealed when they are revoked if they had underlying sentences that were stacked with different lengths. Unfortunately, our understanding as prosecutors just isn't the same way that the Court of Appeals says the statute should work. Thus, we are here asking for your support for Senate Bill 412. Are there any questions? I'd be happy to try and unmuddy the waters if I've created confusion.
Thank you. Committee, any questions? Well, you must not have muddied the waters too much because we don't have any questions. Could you just explain to those who are following along the difference between consecutive and concurrent sentences?
Yes.
That's all right. Thank you.
Yes, thank you, Madam Chairman. Concurrent means at the same time. Consecutive means one after the other. So if you have 3 counts and somebody's convicted of 3 counts within a case, the rules, the sentencing rules allow me to run those, or ask that my judge run those 3 counts consecutively, so one after the other, or concurrently. You can also get creative and run 2 concurrent and 1 consecutive. I am limited, or the judge is limited by our statutes to the overall sentence length that I can give. So this doesn't change anything like that. This is not going to be able to extend somebody's prison term or probation term. It just makes everything equal and at the same time when they are ran, when the underlying sentences are ran consecutive. And the probation has always ran concurrently underneath. So if somebody has 2 sentences and we run them consecutive, and each has 12 months of probation, they're not on probation for 24 months. They're on for 12. So we've always done that. It's just a matter now of making that underlying probation period equal or the same for every count.
Thank you for that explanation. Appreciate that. Committee, any other questions? Not seeing any. Oh, yes, Senator Olson.
How many, thank you, Madam Chair. How many cases do you think this would apply to across the state? I mean, it seems like this could apply to several.
Numerous. Like I said, I was baffled when this came before me in 2023. The defendant rightly appealed her sentence. She didn't think her probation should have been revoked. And I'm going, what ground does she have to stand on? She committed a new crime. And then the appellate defender's office was aware of the 2017 Baker case. I was surprised we had not seen it sooner, with people with multiple convictions being ran consecutively or stacked.
Would these people be in jail or prison when their probation's?
These are felony sentences, so when they are revoked, they are sentenced to the Department of Corrections.
Do we have a bed pack impact on this bill? I mean, because I don't see it in here, but I would think there would be an impact.
So I don't think there would be an impact at all, because it's not going to change the way we've been interpreting the statute. If Senate Bill 412 is not passed and doesn't clean up or fix our issue, you would probably be looking at less bed space, but then we would be having to figure out which counts are in play when probation is being filed to be revoked.
So, if I could, so like if there's 3 counts, one's 12 months, one's 24, and one's 36, and you're saying all 3 of them would be stacked on top of each other, 36, if they violate their parole. Instead, say they're 25 months in, the first 2 would then, the way the courts ruled, go away, and it would just be the one 36 month. Am I saying it right?
Right. So if you have, so like in my case, we had the 3 different levels and I filed at 22 months. So yes, the 2 underlying sentences for the level 8 and level 9 expired or went away when the probation term expired, and the court said that she was could only be revoked on the level 7 because that was the only one that was still left because the probation hadn't expired.
So what you're wanting to do, let me get this right, or what normally they run consecutively when that happens normally. But
Your sentences run consecutive,
Yeah.
but your probation length is concurrent. It's always at the same time. We just want everything to be in the same window. So if there's 18 months on one count and 12 months probation on the other count, 18 months be the overall probation length for all convicted counts within the multi-count case.
Okay. Thank you.
And that also then becomes the issue of how do we extend probation on that second count? Because we've tried to create an equal opportunity and give somebody the chance at probation. They should be subject, in my opinion, to that full underlying sentence because I gave them a chance at probation and wanted them to try to reform and not go to the Department of Corrections.
And just one other, if there's a new charge like this lady happened, she's still going to have to go back in front of a judge and a hearing. And there's a possibility she could have additional time on that one too, right?
Correct, and that would be a whole nother case in a whole nother jurisdiction or within my county. And there are statutes that control how a motion to revoke probation is filed, as well as the options we have. You can do a 60-day sanction prior to revoking and sending somebody to the Department of Corrections in our county jail. Our probation officers are given 18 days at sentencing that they can then have people spend in 2 or 3 day increments if they've had a slip up here or there to kind of say, hey, here's the weekend, think about how things have been going. So a full revocation is usually, in my world, the last resort.
Okay, thank you.
Thank you. Any further questions? Not seeing any. Thank you very much for your testimony. Appreciate that. And we're going to ask, are there any other proponent conferees here today? On WebEx either? Not hearing any. Are there any neutral conferees in the committee meeting room or on WebEx? Then we will invite the opponent conferees, Jennifer Roth and Emily Brandt from Board of Indigent Defense Services. Please introduce yourself. And I don't think you're both of those people, but please introduce yourself and welcome to a committee.
I am Jennifer Roth. I am a member of the BIDS Legislative Committee. I'm a Deputy Appellate Defender. I work at the Appellate Defender Office. I have not seen the opponent's written testimony, but I wanted to respond to some things that I heard here today and also to make a couple of points that are not included in our written testimony. By way of context, there's 2 statutes that we've been talking about this morning, and one of them is 216608, which is the statute that tells us how long probation periods are depending on the severity level of the person's offense. That statute has read the same for 24 years. The 2000 legislature made those probation lengths based on severity level, and they've remained the same since then. Also for 24 years, we've had, judges have had the ability to extend the probation at the time of sentencing, not later, but initial term of probation. They've been able to extend that to something longer than what the statute would normally provide, by way of making certain findings, which were referred here today as magic words. But for 24 years, the statute has said that if you are sentenced to probation on a certain level at 8 through 10, that the judge can make make findings with particularity that you should actually be sentenced to a term that's longer. That ability of district court judges has existed for 24 years, and it also exists for higher level offenses, 6s and 7s, that would normally carry 24 months probation. There's a way that a court can depart and give you longer than 24 months. These are options that judges have today and have had for 24 years. The other statute we've been talking about this morning, and this is the one that the Senate bill would seek to amend, is 2168-19. That has read the same for 30 years. As you might recall, last year the sentencing guidelines turned 30. So now we're almost 31 years into the sentencing guidelines. And the 1994 legislature changed the statute that the proponents seek to amend to read the way that it does to this day. And the basis, the overwhelming, or the overall theme here is, as we say in our written testimony, that just as you get a specific prison term as your underlying sentence for each count, you get a specific probation term for each count. And it is our position that there's no reason to change that now. So another thing I wanted to say is that for, I think the entire life of the statute that provides for your probation links, for the 31 years that that's existed, it's always been possible for a judge to extend your probation time if you haven't paid your restitution. So what I think I hear the proponent saying is, well, I'd have to keep track of that to see whether they've paid on that particular count before the 12 months is up. And to which I'd say, yes, I think that probation officers and other people, prosecutors, defense attorneys, we use tickler systems. I say that, but honestly, part of me wonders if that's even a thing, because your restitution might be for your whole case. But let's pretend I'm wrong. I'm getting into the weeds here. Let's pretend that it's true that your restitution is tied to your one specific conviction and that your time is going to run. Then yes, you should check and see whether that person has met their obligations. And if not, the statute does, in fact, for 31 years, provide a mechanism by which you can continue the person on probation until they've paid. Again, I want to go back to this. I was struck. So these are things that have existed for either 20 years, 30 years, 31 years. And the proponents talk about State v. Baker. That was a published Court of Appeals case in 2018. So it has been around for 5 years. And what the proponents were saying is that they haven't been following the statute. So would you please change it? And what I'm saying is that perhaps the way to resolve this is to follow the statute as it's written and has been written for 20 to 30 years. It is our position that if you're going to lock someone up, especially a person who has completed 22 of 24 months of their probation, that you should have to follow the statute. Now, the one other point I wanted to make is that if you are inclined to look into this, then we think you should have to do that in conjunction with some of the recommendations that this body has received over the years from the Kansas Criminal Justice Reform Commission, of which I was a member for a year and a half, and the Kansas Sentencing Commission, of which I was a member a long time ago for 6 years. And that the sorts of things I'm sure you've heard those folks say are about how people on probation need incentives, that they've actually put forward provisions to make it more standardized and happen regularly, that a person be removed from probation early if they have complied. This situation in particular, 22 months of a 24-month sentence, I question why that person was still on probation. Because based on what research shows us and what some of these experts have come and talked to us about over the years, the Justice Reinvestment people, the Sentencing Commission, Reform Commission people, are that we need to, that actually longer periods of supervision are counterproductive. I know that sounds crazy, but it's actually sometimes worse to give people a longer term of probation because they're more successful if it is a shorter length. So if you are inclined to change this statute that has existed as long as it has, I would ask that you do that in conjunction with taking up some of the recommendations made by the Reform Commission and others about standard conditions of probation, lengths of probation, early release from probation, and that sort of things. We have a lot of real problems with the sentencing guidelines. In fact, I could come here and talk to you all day about them, but you wouldn't want that. But this isn't one of them. If we want to address issues with the guidelines, there's real ones we could address, and this isn't it. Thank you for your time.
Thank you. Committee, are there questions? Yes, Senator Wilborn.
Thank you, Madam Chair. Thank you for being here. I noticed you said a judge can impose a longer sentence prior to the probation period. Can they shorten the probation?
Yes. So right now, and this is also, I think, existed the entire life of the guidelines. There is a provision in 6608 that says that a judge can end a probation at any time, something like that. Then there's also a provision, at least I think it's still there, in 6608 that was the product of Justice Reinvestment in 2013 about if you've done, I think it's 12 months of your probation. I can't remember the exact words, and I don't have the whole statute, I'm sorry to say, but that there's actually like a more pretty specific provision in 6608 about how you can move to be released from probation early. Thank you, Jenna. So that does exist. But what the Reform Commission, they had a subcommittee that was about probation and supervision terms and supervision conditions. And so the idea was, is there a way to make that even more of a thing that happens regularly as an incentive to people on probation? But sorry, to answer your actual question, there is a mechanism by which a person can be released early.
Thank you. Committee, other questions? I see in your written testimony that one of the points you bring up is that the bill decreases the personalization of non-prison sentences. Did you cover some of that in your testimony when you were talking about it's counterproductive to be on probation longer, which does sound also counterintuitive?
That's the word I'm looking for. I couldn't remember if it's counterproductive, counterintuitive. Yes. So as far as that last part of our testimony, it's hard for me to put into words. Luckily, Emily did a great job. This idea of what the proponents are asking for at this point, how contrary it is not only to the idea that each count gets its own probation length and sentence, but also just what we know now about how probation should work, how people need incentives and things like that. So when I was kind of going on about what you've heard from the Reform Commission or Justice Reinvestment, that's the section I was kind of referring to.
Thank you. Committee, any other questions? Not seeing any, then thank you for your testimony today and for appearing in committee. And I don't think Emily Brandt is present to provide testimony. She helped with the written. Thank you. Are there any other opponent conferees in the committee meeting room or on WebEx? Not seeing any. Then we'll note that there is written testimony from the conferees in your committee folder, and also available online. And thank you for the testimony. We will then close the hearing on Senate Bill 412. And with that, committee, then we do have a few minutes to review the meeting minutes from January 30th and January 31st, 2024. They are part of your materials on your desk. So I'll give you a moment and then entertain any motion. Have a motion from Senator Olson and a second from Senator Haley. And I believe the motion is to approve the meeting minutes from January 30th and January 31st, 2024 as presented. Any discussion? Not seeing any. You all have heard the motion. All those in favor signify by saying aye. Those opposed, same sign. The motion carries. Committee, we did have on our agenda possible final action on bills previously heard, but want to be respectful of committee's time. And if we could just stand at ease for just a moment. Committee, we are standing at ease for just a moment. We have a possible bill introduction, and this is our last day to do that. So want to leave the meeting open for just a moment. Committee, thank you for standing at ease for a few moments while we confirmed the RS number. And with that then, Senator Haley has a request for a bill introduction. Go ahead, Senator.
Madam Chair, I greatly appreciate your and the committee's indulgence. I'd like to introduce, and this is our last day, 24 RS 2990. If I might, please. It's regarding the open container laws of our state.
Thank you. With that, the bill will be so introduced.
Thank you.
Thank you. And thank you, committee, for your attention, to staff and to those following along in the committee meeting room, to our conferees and following along online. With that,